versus Frymark, case number 244989. The record should reflect Miss Frymark's present here in the courtroom today. This is the date and time set for sentencing in this matter. And Miss Frymark, have you had a chance to go through the pre-sentence report and talk to Mr. Seeger about that?
Yes.
Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor.
And do you have any challenges to the scoring of the guidelines?
I do not, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
Just one, Your Honor, on the face sheet under the plea agreement. It says the defendant was found guilty as charged by jury trial. The defendant was actually found guilty of a lesser included charge.
Any objection to that change, Mr. Seeger?
No, Your Honor.
Okay, the court will order that the report be amended to reflect that the conviction was actually on a lesser included as opposed to the charged offense. Any other corrections, Mr. Ziegler?
No, Your Honor.
And do you have any challenges to the scoring?
No.
I believe the report indicated that the officer suffered injury did not wish to give a statement.
I'm not expecting.
Okay. Anything on behalf of the people for allocation?
Your Honor, there's very little to add to the report and to the day of the testimony and the video that this court observed overseeing the trial. Was this the crime of the century? No, Your Honor, it was not. Was it the RNO of the century? Also no, Your Honor. But due to nothing other than the defendant's utter unwillingness to meaningfully comply with a simple command, a dog is now dead and an officer was attacked. This was an entirely avoidable incident, and the jury found that the defendant was responsible, at least in part, or to some significant degree, for allowing that to happen. The recommendation of the PSI is for fines and costs only. I understand that recommendation because I agree probation is probably not the right sanction in this case. This is not a situation that's likely to recur, and there is little to be gained for Miss Frymark or by the community for monitoring her. However, I do think some punishment is warranted, Your Honor. This is the defendant's 5th felony and 11th conviction overall. The offense resulted in injury to an officer. I do not believe that 1 day of jail and fines are a sufficient sanction for that conduct. The guidelines are 0 to 11, and while certainly there are mitigating circumstances in this case, I feel obligated to recommend a punitive sanction to the court that sends a message to Ms. Frymark and to the community that when an officer gives you a lawful command, you obey it. I would ask the court to order 14 days jail with no probation and the attendant fines and costs.
Thank you, Mr. Seeger.
And Your Honor, the court sat through the trial, so there's really much like Mr. Ziegler stated, there's not a whole lot. The only thing that I can say, Your Honor, is to my vantage point, I still feel as though Ms. Frymark was wrong. Whether or not she followed a lawful command was decided by the jury. Ultimately, now it's in front of the court for sentencing. But on that day, Your Honor, she had called law enforcement because she needed help. She was intoxicated at the time that they came out. I feel as though law enforcement could have handled the situation better. Mr. Ziegler had said that there was a determination that there was an injury to a law enforcement officer. That was not the determination of the jury. In fact, they determined that it was resisting and obstructing. But I would agree with Mr. Ziegler in as much as we're characterizing, one resisting and obstructing as it relates to another. This is not the alleged resisting and obstructing of all time. This was basically, at best, looking at a light most favorable to the prosecuting attorney and based on what the jury had determined that she failed to follow a lawful command, i.e. that when they had told her to put the dogs back in the house, the dog wasn't immediately put back in the house. But it wasn't a case where she was actively resisting in any way. It was a case of, I guess, to a certain extent, omission, if that's how the jury construed it. But be that as it may, Your Honor, there's nothing to do in terms of probation because this is not a situation wherein probation would be appropriate. I disagree with the prosecuting attorney in terms of jail. It's a wholly unfortunate situation. First, her dog is dead. Second, she called law enforcement for help and her dog is dead. I don't know how best to characterize this, Your Honor, but I do generally say this as a general rule. that calling law enforcement where ordinarily that should be a helpful situation, at least in my acumen, having dealt with law enforcement for many, many years. It is not necessarily in everyone's best interest to call law enforcement, even though theoretically you should be able to reach out to them and they should come out and help you. But nothing good comes of calling law enforcement. And in this moment, you know, when she had taken the beating, if she had never called law enforcement, you know, maybe she would have gotten it worse, but her dog would still be alive and she wouldn't be sentenced for a felony. And so I wholly disagree with Mr. Ziegler, at least in terms of what should happen. I would just ask the court to limit it to court costs and fines. The probation department went through the report, they looked at the facts, they've made a recommendation to the court. The court is in the perfect position to determine what is just and reasonable, having sat through the trial. But just from my vantage point, I would just ask the court to limit it to court costs and fines. She's lost enough. She's lost her dog, who she cared very much about. She got assaulted on that day. I don't know how things could get much worse for her, other than her now being convicted of an additional felony. So to that end, Your Honor, I would just ask the court to consider limiting it to court costs and fines.
Thank you. Ms. Frymark, anything you wanted to say today?
Sorry it ever happened. It was a bad day for everybody.
Yeah, I think that's a good way to characterize it. I don't think anybody left that situation feeling good about everything that happened. So obviously, I sat through the trial. I'm very familiar with the facts of the case. I watched the videos just like everybody else did. And you know, I think the jury's verdict here is a classic example of what we call in the law a compromise verdict, because there was clearly enough facts to establish that there was an injury here. So I think the jury clearly felt that there was some culpability or wrongdoing on your part. But even in light of the evidence, they felt like they didn't want to convict you of the higher charge, because they feel like maybe things could have been done differently, I think, probably. I also think it's interesting, just it's people's perception of an event, and their interpretation of various actions as they view it. I always think it's interesting because I hear the prosecutor's version and I hear Mr. Seeger's version, and I can see both of their sides. But it's definitely something different than what I saw when I watched that video. And number one, I think it's incredibly unfortunate that you're a victim of domestic violence. That I completely agree with Mr. Seeger. Nobody deserves that. Nobody should be subjected to that. And I have a great deal of sympathy for you for being in that situation and enduring what you had to endure. And I hope that you're able to get yourself out of that if you haven't already. But I also think that the police showed up with the intent of helping you, but in the condition that you were in, and I watched what you did and what you said, and how intoxicated you were. This is not a situation where the police showed up and just decided they didn't want to help you. You were incredibly uncooperative. You didn't do anything to help them help you. And if anything, you made it more difficult for them to help you because of the condition that you were in and your actions, because of your level of intoxication. So to paint this as you shouldn't have called the police because they showed up and all they did was not help you and shoot your dog, that is just not what happened. They showed up to try and help you find this individual and take him into custody. Because of your actions, at almost every step, that process was made more difficult and resulted in what was an unfortunate thing. I don't think that officer, who is a canine officer, wants to shoot another dog. He's clearly an individual who loves animals and loves dogs, and appreciates the value of what dogs can bring. And I think everybody was put in a position where he's not going to put his dog's life at risk because you were too intoxicated to be able to control your pets and really had no interest in controlling them. You were mostly interested in blaming the police for what this person did to you. So all of that being said, I'm saying all of that just to illustrate the point that this circumstance can be viewed from a lot of different angles, and that's the way I view it from. And I tend to agree with the jury's verdict in that there was certainly some wrongdoing on your part, but I think there's some mitigating circumstances. In terms of punishment, there's different ways that the court can punish a person. Jail is one of those ways, but financial fines is also a punishment because it requires you to pay money, and you can't do other things with that money that you want to do. So in this case, given all the circumstances and the facts, I think the appropriate punishment here is a financial punishment as opposed to incarceration punishment. So I do agree with the recommendation. The court is going to sentence you to fines and costs. So the court is going to sentence you to a crime victim's assessment of $130, court cost of $68, attorney fees of $350, a $68 state cost, and a $500 fine. The court is going to order that you serve 1 day in the Calcasas County Jail with credit for 1 day served. You do have the ability to appeal this sentence, and Mr. Seeger, if you can now for appellate rights, we're going to provide you with some papers, Ms. Frymark, to explain to you what your appeal rates are, as well as thank you. And then, so Ms. Frymark, you just need to go across to the clerk's office and make arrangements. And that's all we got for today. Good luck to you.
Your Honor, could I just have a moment to try and see if Mr. Smith is here, which he's supposed to appear by Zoom, albeit he's not lodged.
Okay, I do not see him in the Zoom meeting room, just FYI.
Well, that took a turn. The sentencing hearing for People v. Frymark was a perfect example of how complex, layered, and deeply human courtroom moments can be quietly heavy, with plenty to unpack. Judge George Mertz presided once again, bringing his usual combination of legal precision and perceptive commentary. You could feel that he took the time to watch the video evidence closely, listen to both attorneys, and weigh what had been a tough situation from multiple angles. Miss Frymark was present for sentencing, and both sides had clearly been preparing for this moment. The prosecution, represented by Mr. Siegler, didn't hold back. He acknowledged that this wasn't the most extreme case of resisting an officer, but made the case that the consequences a dead dog and an injured officer warranted some kind of punitive measure beyond fines. He also emphasized Frymark's history, 5 felonies and 11 convictions, a record that understandably gave him pause. His recommendation, 14 days in jail with no probation. Mr. Seeger, for the defense, took a different angle. He didn't argue that his client's behavior was perfect, far from it, but framed the incident as a tragic spiral. Miss Frymark had called the police for help after being assaulted, was intoxicated, and in that chaotic moment things went sideways. The crux of his argument, her omission failing to quickly secure her dogs, wasn't active resistance. And the fallout? Enormous. She lost her dog, suffered injuries, and was now staring down another felony. Seeger painted the jail recommendation as excessive, asking the court to follow the probation department's more lenient recommendation. Fines and costs only. Then Judge Mertz weighed in, and this is where the tone of the hearing really came into focus. The judge didn't sensationalize, didn't minimize. Instead, he walked through the event like a calm observer who had seen the situation unfold from all sides. He described the verdict as a compromise, not quite a clean win for either side, but a nuanced middle ground. He also pointed out that while law enforcement came to help, Miss Frymark's extreme intoxication made that help nearly impossible. Her behavior, in his words, turned a bad situation worse. And yet, he also extended real empathy, acknowledging the domestic violence she had endured and noting that no one walked away from this feeling good, Ultimately, Judge Mertz decided on fines and costs with no further jail time beyond the single day she'd already served. It was a balancing act holding her accountable without making the punishment feel disconnected from the broader context. His ruling acknowledged both legal responsibility and human complexity. And you got the sense that justice wasn't being reduced to just checking boxes. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.